Patricia Van Haren, family law attorney. What happens when I'm having issues coming to decisions with my former spouse about my special needs child? Co-parenting with a former spouse is difficult under the best of circumstances. However, when there is a special needs child involved, the issues may arise where the parents are not in agreement as to what is in the best interest of the child in regards to their safety, health, education, and welfare. We have many cases where one or both parents believe the child should live primarily with them and that they should be in charge of making the educational decisions for the child. In all of our cases with special needs children, we put details in the judgment which will anticipate the needs of the child in the future. And we also create the ability for the parents to work together in the best interest of the child. However, sometimes even the best judgments do not continue to suit the needs of the child. It takes a joint effort on behalf of both of the parents to successfully co-parent a special needs child and navigate the special education system within the schools. In cases where the parents have joint custody and there is a disagreement as to what services the child should receive for their special education, or whether the child should be enrolled in particular therapies, see certain child specialists, or participate in behavioral training for the parents, they may need to seek court intervention or attend a mediation session to resolve these issues. When determining whether there needs to be change in your custody agreement because of the special needs of your child, it is important that you gather all the appropriate evidence and assemble the appropriate team before you enter litigation. Make sure that you are speaking with any specialist your child sees, any therapist. You've gathered all your IEPs for that child. You've consulted with any existing therapists, medical professionals, and school professionals. You'll need to put together a solid evidence file so that you can present this to the courts and so that your attorney can get the appropriate experts in the event that this is a contested case. With special education children, it may be appropriate to appoint minors counsel so they can review the evidence and advocate for the needs of that child. The parents may come to an agreement on hiring an attorney for their child through a collaborative process or through mediation. The parties would jointly agree on the attorney and they work collaboratively with that attorney to find solutions for their special needs child. If there are no agreements between the parents on having an attorney appointed for the child, then one of the parties may need to go to court and file a request for order to appoint minors counsel. Minors counsel would then be able to speak with the professionals involved in the life of the child. Once minors counsel has completed their investigation and has met with both the parties, professionals, as well as met with the minor child, they would then advocate a parenting plan and could possibly request that the court assign educational rights to one of the parents. It should be important to note that minors counsel is not a custody evaluator. They are merely an attorney and advocate for the child and their best interests. Therefore, it is important that both parties cooperate and provide the best evidence to minors counsel so that they may make their case to the court and continue to advocate for the best interests of that special needs child. Sometimes it is helpful for the parents to go to co-parenting counseling together so they can learn how to communicate with each other and continue to attempt to work together to find solutions for their child. Parenting of a special needs child can be extremely stressful, and it's important for the child that both parents learn to work together as a team. If you have any questions about whether your judgment or parenting plan is right for your special needs child, shoot us over an email or give us a call.